Welcome back to another gripping courtroom breakdown. Today, we're stepping inside a high-stakes hearing in the case of State versus Matthew Rendone. Now, this isn't just any ordinary proceeding. This is a case involving aggravated assault with a deadly weapon, a charge that carries anywhere from 2 to 20 years behind bars and up to a $10,000 fine. But here's where it gets interesting. Matthew isn't going to trial. Instead, we're about to watch him navigate something called deferred adjudication. For those unfamiliar, deferred adjudication is essentially a second chance. If Matthew plays by the rules, no violations, no slip-ups, he can avoid a final conviction on his record. But if he fails, the court has the power to drop the hammer and sentence him to the maximum penalty. It's like walking on a tightrope with prison time waiting down below. Now, as we listen, notice the judge's questions. They're not small talk. Each one locks Matthew deeper into this agreement. And here's the tension. While Matthew nods along, saying, "Yes, ma'am, yes, sir," the stakes couldn't be higher. Will he hold it together under probation terms, or is this a setup for future disaster? Stick around, because this case has twists, emotional moments, and even a surprising courtroom lecture that might just make you rethink how judges balance justice with compassion. Let's get into it.
Hello. Afternoon. Oh, afternoon. How are you doing today?
Nervous, but here we are.
Hey. All right. The court is calling 2024 CR 2339D State versus Matthew Rendone. Can I have parties announced?
Megan Galloway for the state. Victoria Cruz on behalf of Raymond Martinez for the defense.
All right. And are you Mr. Matthew Rendone?
Yes, ma'am.
All right. Do you have any objections to this attorney standing in?
No, ma'am.
Counsel, have you received?
Right here, the judge is confirming that everyone has the proper legal representation and that all evidence, or what lawyers call discovery, has been reviewed. This might sound procedural, but it's actually crucial. Imagine going into a fight without knowing what your opponent has up their sleeve. Discovery makes sure both sides are playing fair. What's really interesting is that Matthew's defense doesn't push back on anything. No objections, no hesitation. That tells us they're walking into this plea deal with eyes wide open. But here's the question for you. Would you trust the process enough to give up your right to a full trial if it meant dodging the risk of 20 years in prison? Let us know in the comments.
Received all discovery? Did you review it with your client?
Yes, Your Honor. Defense is satisfied.
All right. Court will find that the state is in compliance with discovery. Mr. Rendone, did you review the document entitled Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we move to proceed on count 1 and waive and abandon count 2. No objection from defense.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
All right. You're charged with aggravated assault with a deadly weapon. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you understand?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Rendone, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's a $2,000 fine. If the court finds that a deadly weapon was used, there's going to be an affirmative finding of deadly weapon. The state recommends deferred adjudication, and there's restitution, if any, to Oscar Del Fierro. Fierro?
Yes, Your Honor. Yes,
All right. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
Your Honor.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 200 hours of community service restitution, no contact.
And here it is, the heart of the plea deal. Matthew is looking at 5 years of deferred adjudication, meaning he won't be labeled a convicted felon today. But the terms are steep. $2,000 fine, community service, hostility management classes, and, most importantly, an official finding that a deadly weapon was used. That last part sticks like glue. Even if he avoids prison, the deadly weapon finding follows him, making future consequences harsher if he messes up again. Now think about that. Is deferred adjudication really a lifeline, or just a leash keeping? Someone one mistake away from maximum punishment? Drop your take below.
With Oscar Del Fierro, Anthony Cochran, Richard Campos, and the hostility management course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead to count one? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offer states one in attachment. No objection from defense.
All right, state you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, please.
Anything you wish to say on behalf of your client?
Not at this time, Your Honor.
All right. Are you currently employed?
Yes.
What do you do?
My family has businesses. I do stocks on the side.
You say stocks?
Yeah, like stock market. I'm an investor.
Oh, okay.
I do a lot of entrepreneurship. It's
Okay.
that category of work.
How's stock investment going?
I don't like to get political with it all.
No.
It affects it, but it's good. I make good percentages yearly. Good point.
No, I asked that. I have friends who do the stock market and they're always coming to me and I'm like, don't get married to the stock. Don't marry it.
A lot of discipline.
Oh, it is. All right. Do you have any children?
Yes, ma'am.
And what are their ages?
I have a 4-year-old son and a 3-year-old daughter.
Okay. All right. This is what the court will do. The court is going to sentence you to 5 years deferred adjudication. There's an affirmative finding of deadly weapon. There's to be regular reporting by Zoom or in person, regular random UAs.
The judge just locked in the deal. 5 years of deferred adjudication. But notice the layers being stacked. Random drug tests, employment proof, parenting classes, hostility management, and strict no-contact orders with the victims. This isn't freedom. This is structured surveillance disguised as a second chance. What stands out most is the judge's reasoning. Parenting classes, not just as punishment, but as a reminder that Matthew's actions ripple through his children's lives. That's powerful. But do you think judges should focus more on rehabilitation, or should they stick to punishment alone? Because here, we're watching justice walk a tightrope between mercy and control.
$2,000 fine probated. There's to be restitution, if any, to Oscar Delferio. State, when do y'all want the restitution hearing set? All right, can I have 30 days for a restitution setting, please?
Yes.
Sure. And it may be a restitution amount that they agree on, but I've learned that when you don't set a restitution hearing, it just floats out there.
Yes.
And so I want you to be able to know what the amount is.
Judge, do you give me just a second? I'm looking up another birthday book for Megan.
Okay.
I'm just trying to get it.
Oh, no problem. All right, while they're doing that, I'll continue. So there's going to be 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service will be deemed satisfied. People always wonder, why do you order parenting classes? And the reason why I do it is because when people are making these choices, they need to think about their children as well. What would happen if I go to prison? And, they're not really thinking about that. They're in the heat of the moment. And let me do this. There's going to be parenting classes, 100 hours deducted for the parenting classes. And then I'm going to order the hostility management course that was recommended. And then once you complete that, the remaining 100 hours will be deemed satisfied.
Thank you, Your Honor.
There's to be no contact with Oscar Delferio, Anthony Cochran, and Richard Campos. And there is to be proof of employment within 30 days, no employment as a home health care provider or with minors. Probation, is there anything? Thank you. Field visits 1 time per month for 5 months. Anything else, probation? Is there anything else you need from the court in order to be successful? No. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. Do we have a date?
July 24th.
All right, so what's going to happen on July 24th? We'll be back here, and that's for us to get an amount of restitution that is owed, and your attorney will have a chance to either object to that amount or agree to that amount. Do you understand?
Yes, ma'am.
So let me explain something to you. When people bring out guns, guess what? If you end up firing it and it ends up hitting someone, there's no turning back from that. You understand? So you're going to have to start thinking and putting your children at the forefront of your thoughts in everything you do, because everything that you do ultimately ends up impacting them. If you go to jail, even if you're in jail for 30 days, getting a bond, it's where's daddy. If you end up going to prison, it's where's daddy. And then that snowballs other thing, because sometimes you have women who will wait for you after you get out of prison. Sometimes they don't. And you know what that means? That means that somebody else that you don't know is raising your child.
Yes.
All right. If you need anything, let probation know. If you feel they're not addressing it, you can always come back to the court. Okay.
Thank you.
All right. Good luck to you.
May we be excused, Your Honor?
Yes.
Thank you.
Let me put this in the system. Everything must go in Odyssey now, and Odyssey is slower than my typing.
And there it is, the judge driving home the point. When a gun comes out, there's no undo button. One trigger pull, and lives are permanently changed. Not just for the victim, but for the shooter's own family. It's a sobering moment that strips away the legal language and lays out the human cost. So here's the outcome. Matthew Rendone avoids prison, for now, and instead faces 5 years of strict probation under deferred adjudication. If he succeeds, he walks away without a conviction. If he fails, he's staring at up to 20 years. This case is a perfect example of how Courtroom deals balance second chances with accountability. What do you think? Fair outcome or too lenient? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Figure out the court on 2 more, please.
Okay.